The petitioner is a proprietorship firm.
Proprietorship firm.
Yes, my lord. And is engaged in data digitization, scanning, and allied IT products, my lord.
Yes.
And enabled, the government has decided to put this company proprietorship firm in tier 1, my lord. Engage him as a tier 1. I have annexure 1, my lord. Kindly have a glance at annexure 1.
What is this?
That the government decided to empower us as tier 1, my lord. Tier 1 company to participate in a digitization program, my lord, of government of Odisha.
Yes. Then?
Thereafter, my lord, they have handed over number of works and we are continuing that works like in Noyagad district court and other courts also. They have been engaged, my lord. Thereafter, my lord, annexure 3, they have decided to debar us, not allowing the proprietorship firm, my lord.
Where?
I have, my lord, page 39. The pre-qualification criteria, they have allowed only, my lord, registered as company, LLP under Companies Act, or partnership firm registered under LLP.
Where is that?
My lord, page 39.
39 I'm looking at.
Yes, my lord.
What do you want? This is what I'm looking at.
Yes,
what?
My lord, para 1, my lord, they have mentioned the existence of the bidder, my lord.
Yes. We have just delivered a judgment.
Yes, my lord.
I think
That
last week.
My lord and sister was assisting your lordship in that matter, my lord.
Yes,
Here,
he was there.
Yes, here, my lord.
Madam, we have signed it, I believe.
You take correct.
Yeah.
Mr. Ajit Roy was
That is, you
we
take
dismissed
services.
ultimately, but
Yes.
you have said that you cannot discriminate.
Yes.
That is the.
We have decided, if I correctly remember, clause 2.2, Roman 1 and Roman 5.
Yes.
So far as the Roman 5 was concerned, we said that it is within the domain of the authorities, no doubt.
Yes.
They can put experience criteria because it is a specialized sector. You need a specialized person, subject knowing person. So we said that that we will not interpret. But so far as clause 1 was concerned, we say is a discrimination. Article 14. When you are incorporating partnership firm, companies, trust, and society, how can you eradicate the proprietorship concern?
Yes, ma'am.
Why are you not bringing that judgment of ours?
My lord,
We have
filed earlier, my lord. So we have I have
don't
known regarding
the judgment. It
recently
is already there on the portal.
Yes, my lord, I will go through them.
Ask Mr. Ajit Roy.
That is petitioner name is
Mr. Prabodh,
you take
you are there.
services.
You were present in the court.
Last
Yes.
Saturday you also delivered that.
Yes. What is that case? You asked Mr. Ajit Roy.
WPC number 13142 of 2026.
Uploaded? Not uploaded.
13142 of 2026. Millard, here the tender is floated by OP number 3.
Yes.
They need to be noticed, Millard. OCAC.
What is the date for submission of the bid?
They have delayed, but they have made the delay. They have not finalized.
Means what? They have extended the time.
They have extended time and again they're extending, my lord.
How much?
Last, my lord, they have extended up to July. Recently,
July.
Yes.
So give a notice. Come back.
Yes, my lord.
Come back. What we think, permitting him to apply and subject to the fulfillment of the other conditions.
Yes, right.
Only so far as the proprietorship concern is concerned.
Yes, ma'am.
Other conditions, yes.
Yes.
My lords have already held that in that judgment.
Yes.
Keeping in view that
Judgment.
Yes, ma'am. Grateful. Yes.
Annexo 6, correct? Annexo 6 along with that.
Item 2.
Just complete it.
Number
Item 2.
May I please your lordships. Miller, the sole issue before this REIT application, Miller, the
6 along with that.
admittedly tender was invited by the benchmark date, the identical mark 3rd January 2026. In 3rd January 2026, the 14.99 was abolished. Miller, after then it was introduced the deposit of additional performance security as per the new rules, Miller. So, Miller, the selection was made, letter of acceptance made, your lordships. That is on, Miller, 27 January 2026. So, the petitioner made applications that since the APS was deleted, you can consider, Miller. But they are,
I could not get
Miller,
it.
the tender was invited, Miller, 20th November 2025.
Prior to that,
Prior to circular, Miller, 3rd January
what was
2020.
the last date?
The last date was, Miller,
Application?
submission was 11 December 2025. Prior to that, Miller, there is a condition, Miller, two type conditions, Miller. The selection process will be done in lottery as per Appendix 36 of the OPWD code, and regarding deposit of additional performance security as per the circular 5th April 2021. Miller, the entire tender process was considered, and the letter of acceptance for deposit of additional performance security, which is 150% of differential
In
about
terms of 21.
21. They demanded, Miller. But
Earlier one.
earlier one,
Correct.
Miller, my
Third.
3rd January 2026,
Yes.
prior to acceptance letter, they two types of order. Firstly, they abolished the 14.98. I am no grievance, Miller. Then, Miller, regarding additional performance security, they abolished the additional percentage of the additional deposit of additional performance security, Miller.
Yes.
Your lordships, kindly the circular, your lordships. That is Annex 2 circular, I am a subsequent circular as well as the, Miller,
Which circular?
that
21
is
circular?
103, Miller, office memorandum.
Okay.
Your lordship, kindly see, after careful observation of the government has been pleased to abolish the exempt provision threshold negative cap bid of 14.99%.
That is the 26.
Yes, your lordship. That is Miller, that I am saying that in next part, your lordship.
Yes.
Number 1, additional performance security shall be taken on incremental basis from the selected bidder, low bid price of the project works under, where the price is below 10%. Miller, I am in serial number 2. My price is, when the bid price is below 10%, but not below the 20% of the project cost to bid, the additional performance guarantee security percent shall be increment 0.1% for every percentage of the bid. Price below 10% of the project put to the bid starting 11%, with the additional bid performance guarantee being 0.1%. And this additional performance guarantee percentage shall be applied on the bid price.
Right.
Miller, this is the circular, Miller. Then your lordship, they clarified, your lordship, Annex 6, page 107. The original circular was clarified, Annex 6, Miller. This is the clarification, Miller.
Yes.
Your lordship, kindly see the clarification, clause number 4. But they, as the regards the bidding process, which the tender has been floated before
As per the earlier.
exactly, Miller. This clause is only regarding selection. Your lordship, kindly the language, Miller. There is two part. The tender process finalized before the issuance of the process shall be finalized as per the Appendix 30 of OPLW. So
Not two part. It is single part that any tender which is floated prior to 3-1, even if it is finalized subsequently, but that finalization will be in terms of earlier.
exactly.
That's
Your
all.
No, what I am saying to say, Miller, the additional performance security and finalization is two distinct, Miller. One, Miller, the 36 provides of lottery, that selection process, and the additional performance security to be deposited. There is no saving clause, the additional performance security.
What is this in clause 36 of the OPW?
Your lordships.
What is that?
That is, my lord, of conduct of lottery. Your lordship. I have made Xerox.
And the additional performance?
Easy circular, they have
That's all.
so, my lord, my humble submission, your lordship, kindly see the demand, annexure 4. That is, your lordship, page number 102. Your lordship, hence you are requested to deposit as per the circular. So, my lord, my humble submission for this honorable court, once the circular is ceases to be operated by of date of acceptance, you can't demand is a circular which is no more existence, my lords.
No, sir. Sorry.
No, your lordship can, my lord, your lordship can
No, page 104 clause 2.
plus 2, your lordship, 104, your lordship.
Prospective effect. That's all.
No, your lordship,
Page 104.
your
clause
lordship,
2.
hence you are requested to execute agreement,
No,
sir.
104. That first notification of 3.1.
Yes,
Clause 2. Para 2.
my lord, page
Page
100.
104
These
of
are
that notification of 3.1.
Yes, your lordship.
Where-
102, your lordship, 102, sorry, my lord.
104. See, I don't know, but it is given to me 104.
Annexure 4, Annexure 5,
Yes, your lordship.
second page,
Second page. Yes,
clause 4,
2.
2.
your lordship. This amendment shall, yes, my lord, I am.
So if this amendment is from the date of 3.1.
Exactly, my lord.
That's
No,
all.
no, my lord. Your lordship, I am just, my lord, I am only 2 minutes, my lord. Your lordship,
Who
kindly.
is the
Your lordship, similar circumstances when 2021 circular is, your lordship, this honorable court pass an order, interim order, my lord. This still pending. No, your lordship, just a my lord.
binding on us?
No, I am not.
It's not binding on us.
No, it's not binding because the coordinates when. How the two coordinate wins. No, Miller, I am just clarifying there is a 2 distinction, Miller.
Finding on a law.
Sorry, your lordship.
Where is a finding on a law? You are relying on a judgment. Tell me one line where any law is stated. Tell
No,
me.
Miller is an interim order.
So-
Miller, I am only.
No, even in the interim order, show us
The
one line that the law is stated.
your lordship that.
Tell me, show, read any line
yeah.
from the judge.
Exactly, Lord. Your lordship said that I am.
Read.
Lord, I am WPC number 18892 of 2021. Here is a bit.
Mr. Prabhu, what happened to the final result of this case?
This is pending, Lord.
No,
the contract was
it is-
executed and the
No,
sorry.
No, 6/5/2024, it is disposed of. JBS Construction.
That is a contract awarded because of infructuous. Because of the
So
personal.
the interim order remain for all time to come.
No, Miller.
So you are relying on interim
Petition
order.
is disposed of or dismissed. Interim
Interim
order will
process.
remain. That
No,
is
Miller.
what is-
I'm just Miller showing Miller the
Sorry.
favor.
Mr. Prabodh,
Miller.
this sort of,
No, Miller, because they have
I don't
accepted.
expect, sir, from you, at least.
No, this was.
Mr. Prabodh,
Yes, your lordship, correct. But your
at
lord.
least I don't expect from you such type of
Yes,
stark practice.
No, Miller. I am saying that this
Mr.
apply to principle.
Principle.
Are you not aware of the proposition of law? First fundamental first principles of law. The interim order is always passed in aid of the final relief. It cannot travel beyond. the lifespan of a proceeding. If the proceeding got dismissed, what is the effect? The interim order merges with the dismissal and no longer exists. And you are citing.
You know Anupam Traders. What happened to that?
Lord,
You know very well.
yes, yes, my lord. That, my lord, I
That
am
is
on
also
second.
tender matter went up to Honorable Supreme Court. Withdrawal was permitted here.
Yes, my lord.
You know that very well.
Yes, yes. My lord, what happened,
Mr.
my lord, next, my lord, my next point, your lordships. The circular, your lordship, kindly see. The prospective in nature, my lord, it is prospective, my lord. But the date of acceptance, your lordship, kindly see.
It is not relatable. That is what we are.
I am, my lord, that
We are interpreting it.
Lord,
We are interpreting it that
Lord.
what is the difference between a date of acceptance and the date of deciding the tender floated
So,
prior to the amendment.
my lord, it is so date of acceptance is 27 January 2020.
I understood.
But
Understood.
my lord, then second point, your lordships, the once the abolition was already made, my lord, can I deposit, my lord, the same figure which
There is no question of any abolition.
my lord, they have 14 point, they have abolished, no, the APS is APS has been, my lord, they have deleted, my lord.
No, it is not.
My lord,
It
your
is
lordship,
not.
kindly see the 14.99 and deposit of APS two distinct, my lord.
Yes.
The 14 point, your lordship, one, my lord, last submission, my lord. The 14.99 will be prior to finalization of tender, and the deposit will start, my lord, after finalization tender before execution of agreement. So that I am trying to distinguish, my lord.
Yes.
Once the circular is
The petitioner appears to have Time? 6 days or
7 days.
7 days.
7 days.
7 days? Yes.
Item number 3.
Obligation.
Your Lordships,
The hearing three.
Your Lord, I'm appearing on behalf of the petitioner, Your Lordships.
Yes.
Your Lordships, it's a very simple matter. Basically, the respondent authorities, they floated a tender for the work title, improvements such as widening and strengthening of Bagapalli to Ringali under the bid identification number. Now, in order to participate the tender,
They cancelled the tender,
No,
or you were not adjudged as the highest bidder.
No, Your Lordship, none of these things. We had submitted an AMD amount of 49 lakhs 85,000 and a tender cost on the e-procurement portal. Now,
Correct.
due to unavoidable circumstances in our organization, Your Lordship, we withdrew that bid. So we're just asking for a refund of the MD amount and the tender cost, Your Lordships.
So
Because we've
simple.
not.
It is so simple matter. What is
Yes,
the
Your
rule?
Lordship.
What is the rule? What is the rule whether any bidder would be permitted to resign from the bid? And if what is the consequences?
Your Lordship, we had withdrawn it even before the technical bid had opened. Your Lordship, if you may
No,
refer
I'm
to page
asking
25.
Madam, in many bids, and there it is also controlled by UPWD court. Is there any provision that once you submit the bid, you cannot withdraw? If you
No, Your
withdraw,
Lordship.
is a consequence.
No, Your Lordship. That's why I wanted to point out the provisions from the contract, DPCN. If Your Lordships may come to page 25.
Yes,
Clause 7.2, Your Lordships.
yes.
In the e-procurement portal, withdrawal of bid is allowed, but in such a case, he has to write a letter with appropriate reasons for his withdrawal addressed to the officer inviting the bid and upload the scanned document to the portal in the respective bid before the closure date and the time of the receipt of the bid. The system shall not allow any withdrawal after the expiry of the closure of the bid. Your Lordship, there are two conditions which has to be fulfilled.
When you submitted the withdrawal letter
Yes, Your Lordship. You may
before
turn
the
to
last date,
page.
after
before the
that.
last date,
After that.
No, Your Lordship. The bid had closed around 15 July. We had submitted the letter on 24th June.
or after,
After.
then sir, then madam, then
Let's see, kindly turn to page 17, Miller. Page 17, serial number 6, Miller. The bid shall be received only on online on or before 5:30 p.m. of 9/3/2024. Now, Miller, this application is submitted at page 60,
it's
24.
beyond that. So what is the consequence provided?
Your Lordship, even only one consequence has provided, the forfeiture of the bid. The forfeiture of the EMD amount is only in the case of defaulting bidders, Your Lordship. And they have also defined as to what qualifies as a defaulting bidder, Your Lordships.
Sir, let me understand from this. Suppose this letter is beyond. Have you assessed this petitioner in the technical bid state, treating that there is no withdrawal?
Miller, I have to take instruction, Miller.
Then have you found him in a financial bid, whether he has quoted the best price or the lowest price or the highest price?
Miller, I have to take instruction. I have to take instruction, Miller.
Your Lordship, just one.
There are two things.
Two things.
First thing is that withdrawal is not in accordance with this clause.
Yes.
Then you'll have to consider his bid. Yes. If he does not match the lowest or the highest, I do not know what is the.
अभी बात मत करिए.
But then in that event, there cannot be any default. You have to refund.
Yes.
Unsuccessful bidder.
Is submitted on the same.
Your Lordship, I just have to make two more submissions.
Just a minute, just a. It was withdrawn.
At page 62, Miller, in the six, there are two conflicting statements, Miller. One it is withdrawal, Miller. At 4:29.
No, that is my brother has.
Yes, thereafter
said.
resubmission, Miller.
He say no. It is
Prior to that,
bid
three
resubmitted at 1:32 p.m.
1:34
Then
p.m.
again, you bid, but that was not a last date of submission. Can't be submitted.
Beyond that,
You can't
Yeah.
submit.
yes,
What is this? Resubmitted, and then withdraw.
yes.
now how
Yes,
your
Your Lordship.
system could accept or receive?
Well, at the system, it is there
System
from the
could not have that. That would have blocked submission or resubmission. Submission of bid would have stopped on 15th itself at the last hour.
Yes,
So-
you take an instruction and tell us.
Your Lordship, just one thing I want to point out on page 65, the last date for submission is actually opening date is 16 July and the bid submission start date was
Not
4th
opening
March.
date is not a last date. Last date of submission
Submission
must
of
be prior to opening date.
Yes, Your Lordship. So that we had submitted our letter in June itself, and the bid opening date was 16 July, and
Maybe
the bid.
opened after 1 month, 2 months, there is no difficulty. It all depends upon the wisdom of the tendering authority. Does not mean that they will open it again or immediately.
Your Lordship, but there are no consequences of. There is nothing in
No,
that says
no.
that we cannot.
No, sir. Madam, it says before the closer date. Closer date is the last date of submission.
Yes, Your Lordship. That is 15 July, Your Lordship. We have
So you
submitted.
are submitted on 24th beyond.
No, 24 June, Your Lordship. The submission date is 15 July.
Where is the tender? Show us a tender document that the last date is 2020.
Your Lordship, there only procurement portal I will show page 65, Your Lordship.
I am asking you from the tender document, madam, that what is the last date of submission?
Page 17, serial number 6, Miller.
Yes,
Page 17, Miller.
correct. I am asking you. The bid should be received is
Yes.
that is the 19/3 is the
Yes.
last date.
20.
Show us that the 19/3 was extended.
Your Lordships, I will take instructions and then I'll show you. I'll place some document which shows that it had been extended.
I will take it.
That's it. Very good. On the prayer of Mr. Tripathi.
May so the petitioner was awarded with a contract of a road work. The period was for 7 days, lots.
Where is the annexure 4? Which page?
Page 19, Miller. Your Lordship may see the dates in two documents, my lord, at page 18 and page 19, my lord, within 1 day. I need some instruction in this matter, my lord.
29 is a Sunday.
Annexure 3 was issued on 29/3 and Annexure 4 is issued on 30/3/2026.
What is the duration of the work? What is the duration of the work?
My lord, duration
6 days.
was my lord,
26. No, no, from 26 and
my lord, the commencement date was 26/3/26 and completion is 30/3/2026, my lord. At page 18, first paragraph,
Is this later at 20?
page 18, first paragraph, last line, my lord.
Completion, that is, you are talking about date of commencement.
No, no,
I'm talking-
My lord, the completion is 30th March, my lord.
Okay, so within
30th
3 days he has to complete.
Within
6 days.
6 days. my lord. And here, Lordship will find at page 3, Annexure 3, my lord, the date is 29/3/2026 and its consequence is at next page, my lord, 30th March 2020. I need to take instruction, my lord. And the petitioner has given some
Why you
medical
will not, why you will not do it?
Because of some
It's a
cardiological,
time-bound project,
no,
with this 20
cardiological
days you have
issue,
to
Lord.
complete.
The petitioner was Lordship.
Why you did not intimate prior, you have intimated after 31st? Why you did not intimate immediately on 25th? Yes? Okay.
30th only. Page 22 and 23. my lord.
Approached you on 30th. Approached you on 30th. Your client? Your client approached you on 30th of March. It seems a very good advice was given to him, that's why I asked.
No, no, no. We filed it on 17th. The case was filed on April 17th, my lord. Let my learned friend take instruction, Lord.
He wanted to postpone the dismissal. Vacation he does not want it. Reopening.
Item number 5.
Inspections.
On the prayer of his next.
Item 5.
May I please? This is a tender where the condition of tender has been challenged, my lord. In between, the tender has opened, my lord.
Yes,
Tender has already been opened, my lord. So, if my learned friend will say who is the successful bidder, I will make him party because I want to settle the law because they are not till date. They are
Civil
asking for
supply,
the license.
civil supply corporation.
Na, it is civil, it is SNP, supplementary nutrition program.
Yes, madam.
Once-
Onto the
because-
PSW Dhenkanal.
Hmm.
But if the Lordship may turn to page 5, my lord, the first paragraph. The sole contention is it is deviating the OPWD code, my lord. The sole contention is that, my lord, it is deviating the provisions of OPWD code. Now, my lord, the OPWD code is applicable to the public works. Here it is not a public work, my lord. Only transportation. It's only transportation of food grains, my lord. I will take instruction.
They are asking for the license under the.
It is floated by civil supplies corporation.
No. It is floated by the last tender I have given. That is floated by civil supply corporation, where they have asked for 2 vehicles.
Oh.
Here they are asking for 4, 8.
Oh, that is
Yes.
another one.
In another matter, your lordship has issued notice while sitting with Honorable Justice Pathak, my lord, and that is pending also. For the license, they are asking under the old act, the motor
That's
vehicle.
why you use the words ETA and SETA. Yes. That's why you use the word ETA and SETA.
Again? ODR. Oh, okay. ODR.
ETA, ETA, SETA. Right.
Item number
These are the Bengali expressions which I know very well. That's why I'm saying.
It's and our original expression is similar to Bengali because I belong to Mayurbhanj. For that.
Oh. Instruction.
Yes, sir.
Certification.
item 6.
Petition of bids for 9 works were accepted.
9 works.
Renovation of road and drain.
Renovation of a road. When it is being decorated now.
Abhisujanagar NS.
The repair of the work.
Yeah.
Repair of the road or a
Repair
renovation
of the road and drain.
Anyhow, yes.
The
What is
bid
your
was opened.
demand?
The bid was opened on 2/4/2026. 2/4 last week. Thereafter, no follow-up action. That is the only job.
It is a tender is floated by Kabi Surjanagar NSE, my lord. Notice has to be issued, my lord. The opposite party number 5.
Notice. 1 week after.
Similar other 4 matters are there. I've got the number. You're arising out of same tender.
Is not listed.
Okay.
Item number 7.
Affidavit. My please. Lord, this is a demand of under temporary ID during pendency of the petitioner. Read petition. The petitioner paid the voluntary tax, your lordships, except interest. Subsequently, my lord.
Brother has filed, your lordship, my brother has filed one additional affidavit. The copy has not been served. That is in the cause list.
Today I am additional. I would yes, did have room. And subsequently, my lord, the department recovered my final bill, my lord. Still, the demand is shown in the portal, my lord. The temporary they recovered amount they deposited in original GSTIN, but temporary ID still demand is made. Your lordship, kindly I have that. Your lordship, kindly see.
That is, your lordship, what happened here? 2020, the registration.
Very simple.
Your lordship.
There was a default temporary.
Yes.
They have said that it is showing that you have committed this default. He says that I have already deposited, already done, everything done, but still you are showing in default.
Yes.
That will be done. What is the background?
Get it done.
Your lordship, what will be the background?
Once is over.
Your lordship, what is the background? His RC has been cancelled. Subsequently, his RC has been restored. During the mid period, the assessment has been completed as an unregistered dealer. Subsequently, the RC has been, while recovery has been made, at that time the RC has been restored. So when the RC has been restored, that demanded amount has been kept in the RC, valid RC.
Sir, that is your problem. You have to rectify it.
That will be done.
Once he paid off the entire money, why you will show.
If this is the grievance, that will be done.
That's the only
No,
grievance.
your lordship.
Yes. And with the
But once he is appearing, he never restricts to a original grievance.
Exactly.
He goes
If
further.
that will be the grievance, then I have no problem.
No
That will be
matter.
done.
Milord, that's Milord, they have
Oh,
paid
you
double
will go
tax.
further.
No,
But the challenge is here is something else.
no, Milord, no. I am not Milord, your lordship, they may adjust Milord. And the extra we have doubled. I paid Milord, they recovered. That may be refunded or adjusted Milord. 2 times I paid tax. For they have, I have voluntarily paid, for 1 recovered Milord. That is my humble submission.
The demand has been recovered,
Oh, if it is in excess of a demand,
not excess.
then
That cannot be your lordship.
you communicate to him
Your
that
lordship.
voluntarily he paid.
Your
Once you
lordship.
realize if both the amounts meets the total demand,
Your
no
lordship.
difficulty, communicate.
Yes,
If
Your
it exceeds,
If-
pay,
Your
Yes,
lordship.
adjust.
These parties in additional affidavit. This is not in the pleadings of the
Yes,
writ.
pending
So,
subsequent-
read additional
You have
affidavit.
deposited?
Milord, I tax amount that is Milord, this present affidavit in total Milord, Milord, annexure 8 series Milord,
What is the amount you have deposited, sir?
4,59,536. Milord, I have stated in paragraph 3 of the my,
Same thing is demanded under,
your lordship.
same thing is demanded now.
No, Milord.
Huh.
There is no demand, Milord. That portal shows, Milord, same temporary ID demand still exists. My temporary ID, Milord. The demand which is I paid, Milord, and they have, Milord, I paid, Milord, on, Milord, the 27/12/2025. The recovered amount,
25.
25. And the recovered,
Yes,
Milord,
demand was in
24,
2024.
Milord.
You have deposited only tax amount.
Yes.
What about the interest?
Milord, interest they have recovered on 26 March 2026 from final. Again, tax and interest, both
Both they have.
both recovered, Milord. Still
Your
temporary
lordship,
ID.
let me take instruction. Your lordship, what is there? He has ventilated.
Not there, here we are disposing of. Once you have deducted it, if the quantum is more than your demand, then either you refund or adjust.
Your lordship.
Liberty is given.
Your lordship.
Subject to
If it is
verification.
less or equivalent, also communicate to him. Now, this is the total amount. This is what the recovery done,
Your lordship.
neutralizes. At least the clarity must come
Your
in
lordship. Your lordship. Your lordship.
instruction.
No.
It will delay unnecessarily. This. Call the next.
And
Item number
admittedly, by conceding, he has not challenged the order.
He is not challenging.
Your lordship, his pair is
No.
something
He
different.
says that I voluntarily paid subsequently by mistake both the tax and the interest. Whereas prior thereto you have realized certain more amount already. So he says that there is actually a double payment.
Your lordship.
So you'll have to make an calculation. Communicate to him.
Your lordship. Your lordship.
Where does this portal shows?
Milord, deposit, your lordship.
Portal shows demand still exists.
Milord, I today affidavit, Milord, your lordship can see. This is the portal downloaded, your lordship.
Page
Page, your lordship, 16. The date of demand is still 11/9/2024.
yes.
Your lordship, the date of demand, your lordship. This is your lordship. Kindly see the top temporary ID, right side. Still demand is, Milord, in the portal.
3,64,000.
Your lordship.
3,64,000, 3,64,000.
Tax amount.
Double.
So yes.
Subject to verification, your lordship. Your lordship.
Oblige. I look.
Yes, call the next.
Item number 8.
Item 8 pertains to non-constitution of the GST tax.
9.
Item 9.
9 regarding cancellation of batch.
10.
Item number 10.
That's right on 1073 we might have covered that.
11.
Item 11.
Filing of appeal, Your Worship. Similar order has already been. Filing of appeal, Your Worship. But the session 2020.
GST tribunal.
Non-constitutional appellate tribunal.
Yes, next.
Item 12.
Regarding GST accidents.
Item number 13.
Alert 1474.
Item number 14. Item number 15. Item number 16.
Matter pertaining to 73.
Item number 17.
17, madam.
Lord 17, my lord, may see the writ order at page 75, annexure 11, my lord. The entire dispute arise from this contention, my lord. Here, what has happened, my lord, they are demanding application fee and license fee to the tune of 11 lakhs, which I have already deposited as per the order of this honorable court, my lord.
What?
My lord, can I place this order? Admittedly, the petitioner is a manufacturing of Gudaku, where the molasses are used as the basic raw material. The petitioner was issued with a half margin memo number 8 dated 28 May 2025 by the auditor of Excise Department, Kalahandi, and consequently a show cause notice was also issued with the categorical allegation that the petitioner is running the manufacturing activities without a valid excise license during the period 2017-18 to 22-23, and a demand was initially raised for a sum of rupees 5,45,000. Though the petitioner took a defense in the reply that he has discharged all his obligation as required under the law, in fact has paid an excess amount, but subsequently demand was increased to 76 lakhs, my lord. The instant writ petition came to be filed challenging the said demand with substantive prayer that section 2 subsection 12A of the VR Odisha Excise Amendment Act 1998 may be declared as ultra vires, having offended the provision of Constitution. The petitioner further prayed for an exemption for use of molasses as a raw material for manufacture of said Gudaku industry by using the molasses as provided under section 94 of the said act. The learned counsel, appearing on behalf of on instruction, submits that his client is not pressing the aforesaid two prayers made in the writ petition, and it's restricting the determination to the demand notice, which is also impugned in the instant writ petition. In view of such submission, the prayer number 2 and 3 are hereby deleted, being abandoned by the petitioner. As far as the demand raised by the authorities is concerned, in the counter affidavit filed by the state, it appears that same has been reduced to 11 lakhs. The petitioner seeks for an interim order so that the recovery process as regards demand so raised may be put at halt until the final disposal of the writ petition. The facts are distinct from the record revealed that authorities have varied the quantum of levy which the petitioner is statutorily bound to pay and have substantially reduced the same from rupees 76 lakhs to 11 lakhs, which is reflected therefrom. While passing the interim order, this court must strike a balance between the rights of parties until the final adjudication is made. It would not be desirable to pass a blanket interim order staying the demand raised by the authorities, as it would tantamount to granting a substantial relief claimed in the instant writ petition pending adjudication. The court must bring the equilibrium between the rights of parties pending final adjudication, and there is no fitter on the part of court in putting the parties to terms at the time of passing of an interim order. Since the quantified amount as demanded by the authorities appears to have been varied at intervals, we feel pending adjudication of the disputes involved in the writ petition, the petitioner is entitled to an interim protection but on terms. We therefore direct petitioner to deposit a sum of 11 lakhs 40,000 with registry judicial High Court of Orissa on or before 2nd September 2025.
Then yes.
I have deposited that amount, my lord. Now, what is my predicament is this. Now, because my lord, we don't have this license and I'm challenging the application fee and license fee in that writ petition. Now I'm asking them to give the transit pass because I want to transport the molasses. And I have written them the representation I have given to them, my lord, in Annex 14 and
this transport document permit which
yes,
you
ma'am.
seek for, that is not relatable to 2017, 18 and relatable to that period.
That period because my lord now
No, you seek for subsequent period.
my lord, what has happened, my lord, that license application fee and license fee the my lord's query is that at today's, my lord, why I'm not paying that license fee and application fee is under dispute. Whether at all that license fee and application fee is applicable to this license or not, that is in under dispute in that present writ application, my lord. Here, my lord, I'm saying that because there is only a concept of a storage fee, there is no concept of application or license fee, my lord. Now, my lord, I want to transit this molasses from one place to another place, for which I need a transit pass, and I'm ready and willing to deposit whatever they want to ask for it, and I am ready and willing to deposit. And that is my representation, my lord. Page 98, I have given them a representation. 21 metric ton of molasses, my lord, that I want to, that for molasses transit pass, which is available under section 245.
Now. The main writ application is now pending adjudication. Now,
my pending that, I have already deposited. My lord, if
now separate writ application has been saying that my written is pending, that may be considered. So unless and until that matter is disposed of, to stand. You have to take up the another matter that can be disposed of, thereafter this will be taken up. Otherwise, there is no license. It is a manufacturing unit.
Who's asking for the transfer or transportation of the molasses?
Yeah.
Now, what is the requirement under the law?
That is the manufacturing unit.
Sir, I understand, sir.
Yes.
So,
Now, license is not there.
what would be the charges? Suppose if somebody is permitted, there must be some charge. Suppose if he does not have a license, then also there will be some penalty, some charge. What is that?
That I have to offer instruction to verify that.
Let them take an instruction.
But what are you going to transport?
my molasses, man. 21 tons of molasses.
Excise.
We'll see.
My
Item 18.
press admission. Press admission.
Not same item 73 4 matter common.
Yes.
Item 19.
Regarding RC cancellations.
Item number 20.
May I please the order?
Here I have challenged the introduction of MGR instead of MCQ, that is the policy matter. Now, during the penance of this application, this government has come first in a corrigendum by way of substitution, then there is a subordinate cancellation, then there is a gazette notification. On a similar issue, you will also already had at particular claim. It also pleased to direct the state government to file their response, my lord. So here is the lawsuit's order, similar to my lord. Same issue involved, my lord. So they have only amended the rule. There is no amendment to the parent act, my lord. Section 35 has not yet been amended.
MGR and
MG.
Rules are not framed.
Rules have been framed. Lordship says that drafted rule was never placed for floor for embedding in objects. Yesterday, Mr. Lawrence Senior argued the point. The Lordship has raised a very pertinent question whether it was placed for floor or not. Embedding objects, and that has been not done.
And they have extended item was 1 double for double 2. Roth was arguing this matter till common Monday. All this matter can be tagged. Suppose the list so that can dispose of.
Are you deprived him of today's appearance?
Practice करिए नहीं भाई बहनों को practice करिए देवे नहीं
All time it can be settled, Lordship. So
up to 23. 7.
Question is same.
21, 22, 20, 21, 22, 23.
23, madam.
Yes. 24.
Item 24.
So matter, your lordship, in fact, batch of cases were pleased to hear this matter and pass orders. Yesterday, those matters were for the purpose of passing orders. Yesterday, item number 49, that prevalent. They extended the period of license for 2 months. They are supposed to collect license fee and duty as per the prevalent policy. Prevalent, I have got judgment. You asked me to supply judgments. Prevalent means current. Current. As on the day when you are passing.
No, that is, I know. Prevalent means the current.
Right. If your lordship, it will be. Honorable Jharkhand High Court judgment, Tara 49, 50 and 51. Is a persuasive value, Miller. Para 49. The word prevalent is given the following: that exists or very common at a particular time or any particular place, or the prevailing is given synonym to current. Dictionary has been defined. Dictionary, they have taken help of the dictionary and is arising out of an order passed to the commercial court.
What is the issue? Find out.
Annexure 1. Government says as per the prevailing excise policy. Kindly see note Annexure 1, page 14.
License remaining means prior to 26 or as on 26/3.
And that is 24-25. Commissioner says just the next page. Kindly see why I am forced to come before your lordship. Page 15. Joint Commissioner says Prevailing excise policy is 26 to 29 on the same day. When the government on the same day is saying prevailing excise policy, that means 24, 25. On the same day, Joint Commissioner says.
So 26 policy will be operating from 1st of
1st of April.
Yes.
Are there to have it?
Yes.
Because it's operating from 1st of April, therefore we have said it's prevailing excise. But this prevailing excise issued by the under Annexure 2, page 14, that has been clarified subsequently because some confusion arose, that has been clarified by the government. And we have already filed a counter in a similar case also. Let it be taken up along with that matter so that it can be clarified. We have already filed counter in some cases, clarified by the state.
But yesterday, item number 49, those matters were there for orders. I can give you the order copy.
When it is directed to be listed for order.
Acha, in this matter, no. Scheduled as or interim order. But probably my learned friend Mr. Swami is referring to this now.
Yes.
There has been an interim order also here.
We are not charging anything more. Only confusion is whether prevailing will be applicable to from 1st of April or from the 1st of June. That we have clarified, subsequently clarified by the government. It was
prevailing cannot be prevailing cannot be 26
from the date of 1st of June. That has been clarified.
First of
Prevailing must follow.
Prevailing as on the date during those 2 months, right?
During the 2 months.
Whatever policy those 2 months were there, that will govern the period, not 26 to 29.
No, 26 to 29.
No, it can't be. Then you'll automatically adjudicate this point.
And one more
thing, rewrite the word English prevailing. You cannot interpret it.
In any way. One more thing,
we are affected because your license fee is increased, MGR is increased.
And MGR will contribute the same.
No. We will not be bound by MGR. We lift the quantity and pay the amount. That's all. Your Lordship,
final hearing of the matter, we have filed in 1 or 2. We have already filed counter.
Your Lordship has been pleased to form an opinion on this. It was reserved for orders.
These we have clarified subsequently, clarified by the government, and we have filed our counter affidavit in some cases. And all these matters are urgent to after vacation also keep it. And in the meantime, whatever if any excess amount they will pay, will be funded. Ours we will not charge anything more. But the scheme is to be implemented, the policy is to be implemented from 1st of April.
It's a question of extension.
There will be no question of financial.
1 second, Mr. It's a question of extension.
To pay anything more financial.
No. It's a question of extension, not renewal. Renewal is a new grant. Extension is existing term. That Dolai's case, my lord. 89 Supreme Court. I did not cite that judgment.
It is a civil matter.
Yes, that's a civil matter. But then, kindly look at the language. Extension. You are extending the license means whatever terms and conditions applicable to me as on that day.
What I am thinking about it, the annexure 1 is issued by the government. And the annexure 2
is Joint Commission.
By the Excise Commissioner.
Joint Commission. He do not have jurisdiction to pass this order.
That is what exception there.
He cannot interpret
from
no, he doesn't have jurisdiction.
What?
And more interestingly,
because you are adding one word.
Yes.
You are adding 2006 to 2009.
Yes.
2026 to 2029. You are adding only this word.
Yes.
Which gives a complete different color.
Yes.
That is true, but subsequently that has been clarified by the government itself.
Where is the government?
That I will produce. That I will produce.
Produce it.
I will produce.
But produce tomorrow.
Yes.
Produce it tomorrow. I mean Monday. Produce it. Let him If the government has clarified, that will clinch everything.
But this may be taken up along with the yesterday's item number 49. All those matters can be disposed of in one go.
That has been assumed to come.
I am giving that list, madam. No. Yesterday was there.
No, it all depends. If he comes with that, then it's all right. If he does not, then ask for more time.
But in that case,
We will direct those matters to be listed in the supplementary list to be published.
Yes.
On that day.
No, in that case, I'll be requesting for passing of an interim order, subject to whatever he comes out with.
Come on Monday. Take it forward.
Item 25.
Lordship, here, Lordship, one step ahead, Lordship, I've challenged this application, the validity of the excise policy. And Lordship kindly see the entire policy. Not only Lordship section 35, your Lordship pointed out that we introduced MGR. Lordship, the entire framework, Lordship, beyond Lordship statutory framework of the Excise Act, Lordship. I can demonstrate, Lordship, one by one. That is not only lacks competency to exist the fundamental rights of the citizens of the state, Lordship. So what I pray, Lordship, because Lordship rightly pointed out section 35, they have violated without amending the statute. They have introduced MGR. And apart from Lordship,
all these matters, Lordship, keeping it to 9th July.
No. What I'm saying, Lordship, tomorrow, Lordship, Monday, Lordship, fix certain matters, Lordship. Monday, let it Monday, Lordship, it can be decided. No, they will commit it, Lordship.
We will not hear. We have promised to the bar that we will not hear any matter which would go beyond. No. If it is there, then 9 July.
9 July.
No, 9, Lordship, here, Lordship.
That is a different matter.
No, but Lordship, here, Lordship, has challenged the constitutional validity also. So, Advocate General should take notice, Lordship. So,
notice to the
Advocate Lordship.
9 July. Wow.
Hearing hearing matters.
How much time?
Every matter more than an hour.
Not an hour, no. Subject to your Lordship's kind consideration, your Lordship may.
After vacation.
Interim orders to continue.
Item 2.
Can be free for a day, subject to your Lordship's.
It will be.
Is that rule 14?
No, sir, that is relating to
Section-
Section 2. The calculation of the VAT return.
2008.
Again, 23D.
No, 2008 amendment.
2008 amendment of
Annexure
the Act.
2 was introduced. Manufacturer has to
Annexure 2 Annexure 2 came in 2009. After the rules have come, 11. So then, laws, our calculation is according to the rules. Now the assessing officer, he devises a new formula, which is not applicable to the present case. And then
corresponding raw material which is not utilized.
But no, it is ITC accrued, but subject to the levy of CST not
Capping is up to the extent CST pay.
Exceeding 4%.
So
20
over and above
20 subsection 3 subsection subclause D.
Exceeding 4% is allowed.
4% or 2%, depending upon the constitution.
Allowable to the extent of CST payable.
And here, Milord, the CST assessments for the period has been already completed. So they also know that what is the CST leviable, Milord. So, Milord, there can't be any confusion. The ITC is known to them. The CST leviable is known to them, Milord. So over and above that, Milord, we have calculated as per Annexure 2, which was introduced in 2009. They say this is not done, Milord. They adopt a formula of this own and they enhance it just because of the audit visit report. So,
I'll convince you. This is a peculiar circumstances.
You will always.
You filed your responses.
Your Lordship,
You filed responses.
I have filed. I have filed additional affidavit. I have also filed.
Item 2.
You are? Solicitor is not here.
Item number 3. Item 3, sir.
Lord, I am appearing for the opposite party, my lord.
After vacation, well, item 2. Yes.
Lord,
Three is not there. Yes, after the question next.
Item 4.
4, my lord, after vacation.
After the session.
Item 5.
Lord, item 5. So, Lord, in the meantime, your lordship may see the order dated 31/5/2020.
You are appearing for?
I am appearing to the petitioner. There was an interim order. And my lord, in the meantime, admittedly, owing to the earlier council having been expired, the writ petition was dismissed for default, and it has been restored, my lord. Now, my lord, in the meantime, what has happened? The writ application is filed on the ground that this instead of allowing the bid in favor of the second highest bidder, the first bidder having failed, they have published a new auction. So that I had challenged.
Rule 36 or Rule 36 or of the OPWD code.
No, this is a sad side, Atmala. So, my lord, in the meantime, this has been pending. What I pray, your lordship may relegate me to the authority, but they can deal with my representation.
And
There is an interim order.
Then we'll have to set aside that.
Yes.
Where is the rule?
Yes, my lord. Rule 46, my lord. I say.
See.
But here, in the meantime, though, no counter has been also filed.
No counter has been filed.
But no copy has been served.
Sir, wait.
Nahin, doctor. Acha, my lord, then allow me to take the copy because I don't have a copy. It must have been served on the earlier council.
Submitted by the council for the petitioner that the copy of the counter affidavit. Copy of the counter affidavit, sir.
Pleadings ready, Lordship. I have also rejoinder also. Here, Lordship, two questions to decided. Illegal cancellation bid and Lordship allowing a single bidder, but which is both are not permissible either on law, Lordship, or on the terms of contract. It is to be decided, Lordship.
Shows the provision not permissible, shows the provision
Lordship,
permissible.
it is reported.
That's the only argument.
No.
Nothing more than that.
First, Lordship, first point is, Lordship, they have illegally rejected my bid in contrary to terms of the
That's
contract.
true.
Lordship.
Means rejection and
Then
single bidder not permissible.
Not permissible.
Shows
Lordship.
provision.
Lordship, kindly come to state our Lordship first.
Where is the order of rejection?
Order of rejection, Lordship.
Page?
Page 54, Lordship.
Is
Annexure 3, page 54.
reviews. It is not as per the format. Annexures 9.
9, Lordship. May I read, Lordship, they are saying, Lordship, with things rejected of legal status. So, ahead, Lordship, the joint venture agreement uploaded by the bidder is not as per the format provided at Annexure 9 of tender document. Hence, due to non-compliance of conformity documents As per clause number
The
9,
party shall share the rights and obligations, risk, cost and expenses, working capital, profits, losses, other arising out and in relation to execution individually or collectively.
Plus the individual and collectively may be paid emphasis to it. Here change that.
no, Lordship. I let me allow to speak first. Lordship, kindly come to page 30.
Page
30, Lordship. G, Lordship, is very important. 13G, Lordship. Capital G. Lordship, got it at the bottom of the page. In case bidders fail to confirm the online submitted declarations by the submitted documents as B above, there his bid shall be rejected. Then let's see, next sentence is important. However, if the confirmatory documents don't change eligibility status of the bidder in connection with submitted online informations declarations, then their bid will be accepted for opening of price bidders. So Lordship, that's why they are resetting Lordship clause 4.2. It appears Lordship at page 60 of the page 63, page 60 Lordship. The Lordship clause 4.2, the parties shall share the rights and obligations.
that is in case of a joint venture.
Joint venture, Lordship. But the 13G, Lordship, the last sentence is very important for me.
Individually or collectively?
Collectively. That is their Lordship. Because Lordship, first time they have introduced this clause, it is admitted, Lordship. There is, because usual practice, they are dropping the tender, Lordship. So it is definitely that is a Lordship mistake by the petitioner. They have not minutely read the entire tender conditions, Lordship. They have committed mistake, not only this petition, Lordship. For the first time they have introduced. That's why every participant has committed the same mistake, Lordship. But that's why Lordship 13G is the right of the Lordship. 13G. 13G gives a Lordship that if the confirmatory documents don't change eligibility status of the bidder in connection is submitted online declarations, then their bid will be accepted for the opening of price bid. So Lordship, here let's say kindly come to the Lordship the eligibility criteria. This document is never changing the Lordship the eligibility criteria of the Lordship participant. The Lordship he starts from Lordship the eligibility criteria. That's page 20. Page 20, Lordship eligibility criteria. Lordship, kindly see the first they have given work capital A, Lordship work experience. Then Lordship kindly come to B, financial turnover. Then Lordship kindly see the permanent account PAN. D, goods and service tax not applicable for exempted services. Purchase preference and make in India policy for local suppliers. Lordship, these are the requirements for eligibility criteria. These Lordship ingredients never changes the eligibility criteria of a person if or rightly wrongly he has not uploaded in format Lordship. He has uploaded the documents enter Lordship. That profitless not individually has given the entire figure Lordship, but in consonance with 4.2 he is not given Lordship. That's why he is also sought for clarification and also sought for time to submit the same Lordship, because it was their scheme of Lordship, because it was the first time they were introduced in this tender. And usually these contractors are Lordship, the regular contractors.
The fate of the tender.
Fate of tender Lordship.
No interim order.
No, during pendency of the writ application Lordship, because the two writ applications are pending before this honorable court. This one Lordship, this is 17612 and another is 18 Lordship. Lordship, both the writ applications, knowing Lordship, the very day Lordship, kindly see on the date of taking the matter when the common board Lordship, my friend appeared.
Fate of this tender.
Just I'm saying. The two tenders.
Say what is the fate of
one they have come Lordship. I'm arguing Lordship on the ground of honorable attitude. Two tenders Lordship. On the very day that the appearance took time to file, to appear in the file.
Whatever be the
One they have one they have completed.
The right has been created into a third party. I was just thinking in that line, and if the purpose or the tenure of the work which
No,
is to be
if this
complete in all, this is the construction of a road. Has it been completed by this time? Because it is a 2022 affair. Now we are in 2026.
Lordship, now the Lordship, they have not done it. Lordship.
Have we completed it?
No, work order has not been issued on the basis that when we were on caveat, we filed an application IA 14971 before Lordship give us approval to issue the work order. After filing of the IA, your Lordship issued notice in IA also for stay. Thereafter, I have been pursuing this because we are not able to give the work order.
Why you are not? Because there was no interim order.
On when we were in caveat, and we
So
asked,
what?
no interim
What
order is that
impression you have
now the
created?
question is,
There was no restraint order. There was no stay order. What you were doing?
look, we had filed an earlier.
What filed an earlier? Very interesting.
Now the mines has come to what we need to issue the work order.
Mines means the construction of a road.
Road, so that the mines will, coal mines road will be it should be rerouted and the vehicles will move on that. Now mines has come to a closure.
Let it be reopening, Lordship. Issue will be decided only 1 month. They have waited 3 years, Lordship. Let it be reopening, Lordship. Issue will be decided, Lordship.
Lordship may permit us to issue the work order.
How can it be belated stage? After 3 years, you waited last.
Now, whether the L1 will now agree because
Yes, L1 was here. He's there.
They have to be here.
He was here.
That was the price he quoted in
Lordship,
2022.
He is going on giving right that he will do it.
It is very impossible, Lordship. If the Lordship, the subsequent that successful bidder is agree after 3 years, definitely there is something, Lordship.
No, that's something. That's a more benevolent approach.
I am for the successful bidder. I am waiting for last 3 years to do the work. I will do in that work that rate also.
At that rate?
Yes, sir.
I have strong objection, Lordship. So it gives Lordship their Lordship. So issue may be decided, Lordship.
Unnecessarily, it is pending. Why? And there was no restraint order.
No stay order, but they have
better utility.
Well, they have not allowed me to work.
We were on caveat.
So what is the purpose of the caveat?
Another case.
Under section 148 capital A, read.
No, sir, but in one case I faced contempt for that one. Since
I do not know how the contempt will come.
And they are saying that fact they have not allowed me to work also.
I would say I fail to understand the understanding of a law.
Not contempt.
Yes, you are right, contempt against.
I do not know where and how.
That is why we had filed the IA to give us permission to issue the work order.
Can't.
Lordship, allow us to issue the work order.
Let it go reopening, Lordship. Matter can be decided.
Because
I will argue only.
Now the position is then we'll have to decide the matter. You have created a mess.
Legislative reopening, Lordship, first case. Lordship, in fact, Lordship, issue to be decided, Lordship. Lordship, kindly see. Lordship, here, Lordship, kindly see what they're saying. After 3 years, what they will do, Lordship, what the mischief they will do, Lordship. In usual practice, Lordship, we have seen if it is 6 months beyond, tender has to go, first tender say they have by the direction of this honorable court. Because the escalation factor, everything will come. If they will allow to participate, Lordship.
Between the authority process.
No, what they
successful. If he says I will do it at the road.
No, what they will do, Lordship, the mischief they will do, Lordship. They now will agree and the bill will be ended in crores of rupees, Lordship. It is the bills will be ended, Lordship, by way of escalation. In
escalation, if they do not claim, we'll record that they will not claim any escalation.
My humble submission, Lordship, the issue to be decided because the law is well settled. Single.
What you say is
no, Lordship, because I am saying, Lordship, single.
Show us your right.
Lordship, kindly. So, Lordship, Debabrata Samal is a reported case, Lordship. I have given the judgment also. Yes. Single bidder is never permissible in a fair tender process, Lordship. Because the competitive bid must be there.
Show us the
judgment, Lordship, quoted because the Lordship said no hearing matter will take up. So the judgment I have not come, Lordship. Because before case and Lordship has because the hearing matter.
That is under OPWD code and the code was it is prescribed.
Yes, it is applicable. In Minds case, Lordship
has given the documents where single tender is permissible.
No, in Minds case, Lordship, in OPWD code, every case, Lordship, law has been well settled.
Case of a Minds.
No, Lordship, single bidder is never permitted. My friend is definite OPWD code. Law has been settled. Law has been settled in law settled.
Stopping the road within his area.
Yes,
Lordship.
So
I am saying, Lordship, not only in OPWD code, in law of Minds, Lordship, in every tender, Apex Court has held that single bidder is not permissible. No. So that is it.
Show us.
So that I have not brought.
So I have been.
I have not brought.
Your Lordship, this is a hearing matter. It can be posted after vacations, Your Lordship. If I may request, Lordship, this matter can be taken up on 25th. On 2nd of July, Your Lordships.
Item 8.
In this matter, Lordship, the state is yet to file the counter affidavit. However, Lordship, after hearing, Lordship has passed the order of status quo. The last occasion when the matter was listed, the state took time for counter affidavit.
Who is for the state?
The Lordship passed on order directing the state government to take an instruction whether a notification authorizing the collector to de-reserve the Gochar land. As per Lordship direction, we have filed the affidavit along with the notification that my affidavit is there. On the allegation that
he has already filed the affidavit.
I'll place Lordship. Only the interim order while passing the order of status quo, Lordship directed the state whether any notification was issued by the government or not. The main counter affidavit to my writ petition has not been filed. If state is not filed, I'll place Lordship.
On the basis of Lordship direction, Lordship wanted to know whether a notification authorizing collector is there or not. Produce that. In view of that, we have filed the notification. Yes. The main ground is collector is not empowered to de-reserve. That met. And the other allegation that procedure has not been followed, the notice has not been issued, proclamation has not been made. That allegation we have to produce the record and also basically go through that.
Produce the record.
We will produce. But with regard to the main allegation,
know that the record is to be used. Will you not bring the record along with you?
No,
the photocopy or whatever.
Yeah, that part will file. That part will file a regular counter and will also produce the record. The allegation is that
I am just keeping all this in my mind that how the matter is getting delayed so far as the disposal is concerned.
The main allegation was that he has said that collector is not.
Sir, when the point is very small, you know that only the records have to be produced. Why you do not carry the photocopy of the record with you, sir? Is it not a device to get the matter adjourned? Because the matter has to be decided, the justice is paramount. Without hearing, without looking at the document, will you think that there is a proper justice? This is what the state is reluctant in getting the matter disposed.
The affidavits are filed without looking to the records.
I do not know.
No, affidavits supposed to be filed as per the records. So without record, you have filed the affidavit.
Affidavit only with regard to that
So we do
notification.
not know.
Only
You
with
have to
regard to that
verify.
notification, as per lordship direction, we have filed.
You have stated many things. I have seen it.
Lordship's kind permission, I have filed in IA because last occasion when the matter was adjourned, the interim order of status quo was not continued. Taking advantage of the same, despite the order of status quo is there, they are starting construction. For which reason I have filed in IA, that is before Lordship at flag F.
No, question of construction. Those lordships direction was if the no
You are taking out an IA 2026.
My lord, 68
The interim order was not extended.
Lordship, the interim.
Last week, when it is not extended.
Lordship.
9524, not extended. Now 26.
I have filed this IA because now they are taking construction.
Now whatever, come on, the first week of July.
status code is not there in your lordship. You also can see the order 5424. That has been clarified.
Second of sorry, this keep it on Wednesday. After this one matter.
Item 9. Your lordships, sorry to mention, your lordships, in the previous item, I filed my wakalatnama, my name is not reflected. My name may be reflected.
Item 7 achieved. 9 call and 7 can echo.
But demerits. Demerits.
960.
Lordship, kindly read application 960, page 5, Lordship. 960, para 11, Lordship.
Order of restriction.
960.
Renewal of license. Renewal of license.
Petition. Open writ petition.
Lordship, para. Lordship, got it.
Yes, what is this? This earlier order
Let's see.
directing them to take decisions. And saying that if you are aggrieved, it is open to you to go and.
Now, in lordship, by virtue of this order, the entire issue has been set at rest, lordship.
What order? Then nothing has been.
Issue, lordship. They have come to Annex 6, lordship, for a moment.
No, the quotation is very clear.
Lordship.
Annex 6.
Annex 6, lordship.
Annex 6 go. Yeah. So this is order of. This is order of whom?
By lordship, this is by the superintendent of excise, lordship, like this. The direction to the lordship, excise, lordship, superintendent, lordship.
Yes, so his right has been recognized that he has constructed that hotel on the land acquired by him by virtue of a gift.
Now the question
The
was
question is what?
No,
Question is that you are saying disputing the ownership.
Yes. Ownership we
And you are
cannot
not renewing.
ownership we cannot decide because the question is that we have only sealed and we have handed him over the possession, we have handed over it.
To him? Seal is removed.
Yes.
So what more?
Everything has been removed. Possession has been handed over.
The lordship, by virtue of this illegal order, they restrained me to operate lordship since for last 3 to 4 years. Now they've only handed over the lordship premises and not the renewing of license, lordship.
Renewal of license is something different.
That is my problem. You have to order says.
Did you apply for renewal?
Yes, yes, we have applied, lordship. We have applied, lordship.
Where is the application?
That is pending with them, lordship. That's pending with them, lordship. We have applied.
Where is the application for renewal?
Lordship, by affidavit you can supply, lordship. We have applied, lordship.
Bring it on Monday. You will not argue anything.
No.
So far as the ownership part is concerned, the Excise Commissioner has already held his owner.
So who is there is a civil dispute between
Whatever that has been done, you can't decide. You have to hand over.
We have already handed over in possession. We have given possession.
And have you opened your hotel?
No,
lordship.
Why?
They have, lordship, they have cancelled everything, lordship, or hotel license and lordship excise bar license. So that is the personal clause, lordship. I will show only 2 documents, lordship. After the closure of this lordship issue, A person who is saying, I don't know Odia, I don't know, cannot speak English or I can't write English, by making a false signature of a person, he restarted the entire investigation, this collector lordship, and closed the entire shop. The creation of the local collector, now he is no more, not their lordship, he is now at Bhubaneswar, but he has created the entire issue and stopped my entire business.
So whatever the things have come, the registered document has come.
Yeah.
So that's the civil dispute.
Lordship. On that objection, lordship can be disposed of Monday, lordship. Monday, lordship.
Give us.
Item 10.
Lordship, item 10, lordship is not well today, lordship, let it some other day. Petition council.
Item 11.
Yes,
Mr. Dale called me that he will withdraw that matter item.
In fact, lordship, this issue item 6, lordship. In fact, my friend is a tremendous special, lordship. Only, lordship, I will approach before them. They will take a lenient view, lordship. With that observation, lordship can be disposed of. So they are in tremendous pressure.
Agreeing to this?
I will approach them, lordship. Let them take a lenient.
No, is he agreeing to this order? That will be a consent order.
No, approach will approach now.
Hmm.
Again, the work will be stalled.
Work? I am not interested also work. I will approach to take
If
it.
not
You take
interested,
it.
then what should we issue the work order?
No. You take
No,
it.
he's saying that you are agreed. If you agree that they will approach, don't
Lordship.
decide it, then you can say this. And that's not you will decide. Yes, next.
Item 11.
Item 11 may be taken up next week, after revision.
Next week we are not going to hear any.
After revision.
Short issue, madam.
Short issue, but
Not first. No. First week of July.
Yes.
I mean June. The first week reopening July.
Item 12.
Item 12, so only short issue. I have challenged the reception of the contract and
issue, my lords are very apprehensive about short.
no, my lords, they have sought for they have issued show cause notice. I have given the reply without considering, without discussing my reply of the point raised. They have passed the input order under Annex 25.
Are you admitting?
Millet,
Are you taking into consideration the defense?
Millet, in this matter, Millet, we have lost, our file is misplaced, Millet. Let it take it after.
Can you give him a file full? No. One copy so that they will go through it.
The file their file is lost.
Replace him. If you want your early disposal,
Yes, my lord. I will give.
give it to it. Then we are keeping it on Tuesday.
Yes, my lord.
In the meantime, give him.
Counter
Item 13.
Something related to blacklisting, Millard. During the challenge originally portal block, pendency of the course before this honorable court, they issue a blacklisting order, and this blacklisting order without any show cause notice at the time of pending of this honorable court, it was issued, and no reason has been, only codal provision has quoted. There is no reason also assigned. If your lordship see the impung order, if the impung order, which is annexure 1, page 182, only Lords, annexure 9, page 18. 21st, in pursuant to letter dated of Government of Works Department, the Sri Rose Wealth Venture.
Annexure 1 in the bid document.
Lordship, annexure 9 is the improvement. Sorry, Millard. Annexure 9 is the blacklist.
No, I find from an order 28-1. The earlier bench has.
Yes, we are filed, Millard. Affidavit file all the bid documents. Tender note.
Thereafter. So,
Don't-
where is the order?
14th October 2025 order. Your Lordship.
Page 18 of the book. So action is being taken against you for
Then Your Lordship, 14th October 2015 order, Your Lordship.
14th October
2025 order of this
Where is
honorable.
page?
Well, this is the amendment order, Your Lordship, to incorporate appendices of the case, blacklisting order.
Oh, I understand. Where is consolidated copy? You have must have annexed it.
Yes, yes, my lord. Page 182, Your Lordship, the blacklisting order. May permit. In pursuant to letter dated, this is order dated 21st July 2025. In pursuant to letter dated 15 July 2025, Works Department, Sri Rosewell, present petitioner mobile number bearing so and so, is hereby blacklisted immediate effect in pursuant to codal provision under Rule A.
Where is the decision that how you come to know that this is a forged and fake document?
No reason also, my lord, they have
There
assigned.
should be something.
And Your Lordship,
And no show cause was issued.
is not reflected in.
Lordship, kindly turn to page 171, Miller. There is a show cause notice, Miller. That is 12th November 2024, Miller.
Yes.
If I may read, with reference to the subject cited above, it is to state that you had participated in the above mentioned tender during scrutiny. It was found that you have hidden some works that has been awarded to you by other agencies, for which you do not fulfill the eligibility criteria as per the genuineness certificate in Schedule F. It is not filed, Miller. And as per Schedule BP8.
I understand.
Yes, Miller.
I understand. That means it is a concealment of certain
Documents.
information. Order of blacklisting is on concealment. Come to page 182, where you have said concealment.
Here, Miller, let's see for a moment.
Where?
For a
on
moment.
the ground of submission of false, fabricated, or false documents.
Let's see, kindly.
This same so
Let's see, kindly turn to Miller, page 175. At paragraph 8, Miller, they have admitted it, Miller.
Sir, I am asking you a very simple ground. If the show cause notice is issued on a particular misdeed,
yes,
then the order of blacklisting should be based upon that misdeed. Can you take a different route or different ground for which no show cause was issued? That's the only question I am asking. I understand that you have issued a show cause, but for concealment of the document, and you have blacklisted him for filing the post document. For that, no show cause was issued.
Miller, it is written in the order the submission of false, fabricated, and false document.
And show cause, was it issued? Stating that a false fabricated document.
Going beyond the show cause. And specific instances were also not given in the show cause, so that he can file fit reply. Where is the scope for defense? Have you considered it in your order?
Miller, it is order doesn't show that, Miller.
Then how can it be? The law is very clear. If you want to punish him, then on a particular ground, then you must issue a show cause notice on that ground. So he must know that what a case he has to make. You say concealment, he gave a reply, no concealment, and then you say false and false document. Can't.
We did date check for convenience. this is a problem will be. There is several follow that. Till Miller take a decision, I may permitted to participate. That Miller otherwise
The order dated 27 is hereby passed and set aside. Yeah, passed.
Yes. Yes.
The repetition is allowed.
Obliged.
Pending to stop the operation, and on the virtue of that letter, my operation has mining lease has been
I
stopped.
do not know, Mr. Das, how can a letter be issued from the office of the Advocate General when there is no interim order passed in a proceeding? That do not do it.
And till now, my mining has been closed.
I do not know why, under what impression you are giving. There is no preventive order. There is